Welcome to This Explainer. Today, we're demystifying administrative law. I know, it sounds a little dry, but honestly, this is the invisible, kind of nerdy machinery that literally keeps our society from collapsing. Think about it. Every single time you turn on a tap, pay a utility bill, or check the safety standards on a new product, you're interacting directly with this incredibly complex system. So we're going to pop the hood and see exactly how it all works.
Let's take a quick look at the roadmap. We'll start with the birth of agencies, move into rules, rulings, and rates, check out the boundaries of power, and finally wrap up with global standards and local rules. So, who actually writes the rules of our daily lives? You'd probably immediately say, well, Congress, right? I mean, they're the lawmakers. But the reality is actually way more complex. It relies heavily on a whole team of specialized engineers, so to speak. Because let's be real, Congress simply cannot manage all the hyper-specific, highly technical details of modern life on their own. They desperately need help. Which brings us to part one, the birth of agencies. This is our blueprint.
Look, Congress is brilliant at setting the broad strokes of policy, but they aren't necessarily climate scientists, environmental experts, or utility engineers, right? Because of this massive gap, they create specialized bodies. Some of these are actually baked right into the Constitution itself, like the Civil Service Commission or the Commission on Elections. Others are spun up later through statutory enactments. At the end of the day, they exist specifically because lawmakers and judges just don't have the hyper-specialized competence to manage every single intricate aspect of a functioning society. Now there's this old Latin phrase in law, delegata potestas non potest delegari. Yeah, it's a mouthful, but it essentially means that if the people give Congress the power to make laws, Congress isn't supposed to just pass off that lawmaking job to someone else. It is a foundational role. But there is a major catch. Administrative agencies are basically the globally recognized exception to this very rule. But wait, Congress can't just hand over a blank check either. For Congress to legally and constitutionally delegate its power, they have to pass two incredibly strict tests. First up is the completeness test. Basically, the law passed by Congress has to already be complete in setting the actual policy. It should leave absolutely nothing for the agency to do except just enforce it. Second is the sufficient standard test. This means the law has to provide adequate guidelines, things like saying decisions must be based on public interest or justice and equity. These two tests are super important because they make sure the agency is just executing policy within clear boundaries, rather than just inventing new laws out of thin air. Moving right along to part two, rules, rulings, and rates. Let's look at the gears in motion. So agencies essentially wear two entirely distinct hats, and honestly, this is where it gets super fascinating. They don't just sit around enforcing rules. When they exercise what's called quasi-legislative power, they're acting a lot like a mini legislator, creating broad rules to implement a wider law. But when they use their quasi-judicial power, they completely switch gears and act like a mini court, hearing specific cases and settling actual disputes. Let's zoom in on that rulemaking hat for a second. If an agency wants to issue a new regulation, they can't just do whatever they feel like. They have to strictly follow a specific checklist. The rule has to be reasonable, it has to be within the authority they were actually given, and it absolutely must be consistent with the Constitution and the original statute. Plus, it has to be duly published, like, for instance, being filed with the UP Law Center's O&R. And keeping track of the hierarchy here is crucial. While agency regulations are generally presumed legal, if one ever conflicts with a statute passed by Congress, the statute wins every single time. No contest.
Okay, but what happens when the agency puts on its judge hat? Well, when they exercise that adjudicatory power, they have to guarantee you administrative due process. We're talking about fundamental fairness here. It means that before they can make a ruling against you, you have the right to be notified, you absolutely must be given a hearing, or at the very least, an opportunity to explain your side of the story. And whatever decision they eventually reach, it has to be backed up by substantial evidence. They absolutely cannot just decide things on a whim.
And once they do make that decision, we run into a concept called administrative res judicata. To translate that heavy legal jargon into plain English for us, once an agency makes a final ruling on a specific case and the clock completely runs out on any appeal periods, that case is closed for good. It's all about ensuring finality. You can't just keep relitigating the exact same dispute over and over again. Although, a quick side note, this strict finality only applies to their quasi-judicial, court-like decisions. It doesn't apply to their general rulemaking functions. So the really crucial takeaway here is that these combined powers literally dictate your daily life. Agencies have the power to gather data, issue vital permits, and regulate entire industries. Think about rate fixing for a second. Whether it's the cost of your monthly water bill or your electricity, administrative agencies are the ones setting those rates. They can do this generally across a whole industry or specifically target one company, which, going back to what we just talked about, would definitely require that strict due process. This right here, this is the engine actually running. All right, let's get into part 3, the boundaries of power. Time to look at the brakes.
Unchecked power is, well, incredibly dangerous. You might be sitting there thinking, hey, if an agency does something I don't like, I'm just going to sue them immediately. Well, not so fast. Enter the doctrine of primary jurisdiction. This doctrine means that judges will literally wait for the specialized agency to weigh in first. If a controversy involves complex, highly technical questions that really demand sound administrative discretion, the courts actually recognize that the agency knows best, so they step back. They let the experts utilize their specific knowledge before the court ever gets involved. And this builds perfectly into a related and absolutely vital process known as the exhaustion of administrative remedies. Think of this process like a ladder. You cannot just skip straight to the top rung and head to the courts. You must first utilize every single available internal remedy that the agency offers. Why? Well, it ensures an orderly procedure. It gives the administrative agency a fair chance to actually catch and fix its own mistakes. And maybe most importantly, it prevents the premature and totally chaotic disruption of the process that would happen if we dragged every minor issue into an already massively overburdened court system.
Which brings us to our final section, part 4, global standards, local rules. We're getting on the global highway.
We've looked pretty closely at the domestic machinery, but how does this whole system connect to the rest of the world? It connects through the doctrine of incorporation, which is baked right into the Constitution. This doctrine declares that the Philippines adopts generally accepted principles of international law as part of the law of the land. Because of this really powerful constitutional bridge, our local administrative agencies carry a pretty heavy burden. They're constantly tasked with the massive job of aligning our domestic, day-to-day regulatory frameworks with constantly shifting global standards. Just imagine this pipeline in real time. The state signs a major, binding international treaty, what we call hard law. This could be something huge, like a World Trade Organization agreement or the United Nations Convention on the Law of the Sea, usually called UNCLOS. The legislature then steps in and enacts a broad enabling statute to honor that treaty. But who actually writes the nitty-gritty, on-the-ground rules? The agencies. A body like the Department of Environment and Natural Resources or the Bureau of Customs will use those quasi-legislative powers we talked about earlier to draft the Implementing Rules and Regulations, or IRRs. They're the ones translating a global promise into local, everyday practice.
And honestly, it's not just binding treaties either, it's soft law too. We're talking about things like international environmental declarations or global best practice guidelines. Agencies actively use their fact-finding and investigative powers to keep our domestic industries globally competitive and compliant with these benchmarks. And this right here is exactly why those breaks we discussed earlier are so absolutely vital. They stop local courts from prematurely throwing a wrench into our global compliance, which keeps the entire global highway running smoothly.
So, there you have it. The engine of administrative law is vast, complex, and absolutely essential to our everyday lives. Now, you might be wondering if we should explore election law or local governments next, but before we start dismantling those mechanisms, I want to leave you with this one thought. The next time you pay a utility bill, sign a permit, or read about a new environmental regulation, ask yourself, who actually wrote the rules you're living by today? Thanks for tuning in, keep learning, and I'll see you in the next explainer.